Successfully completing this lesson, you will know the origins of MLC 2006, know the broad aims of MLC 2006, know the ratification requirements, know the intended implementation schedule. Before moving on, let us clarify what ratification means in this context. The dictionary gives the meaning of the word ratify as confirm or make valid by formal consent. Ratification of the convention by a member state is therefore an official, formal, and legally binding acceptance of the convention by the government of that member state. This would normally be done by passing appropriate legislation through the national legislature of the member state. It is worth considering the background to the Maritime Labour Convention 2006 before looking at the structure and content. Over the past 8 decades, there have been numerous labour standards adopted by the International Labour Organization. Many of these have never been ratified by all of the member states. Some of the earlier standards are not even applicable to modern shipping practices. Also, in view of the ever more globalized nature of the shipping industry, it was felt necessary to try to ensure equal rights and decent working and on-board living conditions for all seafarers, and to provide a level playing field for ship owners and operators. Therefore, the decision was taken by the International Labour Organization to review and consolidate all the existing labour standards into a single, relevant, internationally agreed and enforced standard. The MLC 2006 is seen as the fourth pillar, alongside MARPOL, SOLAS and STCW, in regulating the international maritime industry. In 1920, the 9th Labour Recommendation was adopted by the International Labour Organization. This was the National Seamen's Code Recommendation 1920, and it was the first recommendation specifically for the maritime labour sector. Between 1920 and 1996, there were a total of 9 maritime sessions of the International Labour Organization, during which more than 65 maritime labour conventions and recommendations were adopted. There was a growing realization that the shipping industry had become truly globalized, and in 1998, the International Labour Organization decided that a thorough examination of all of the existing maritime labour conventions and recommendations was required. In 2001, as a result of the examination, the ILO Joint Maritime Commission came to the conclusion that a complete revision and consolidation of all existing maritime labour standards was necessary. This is referred to as the Maritime Geneva Accord. A high-level tripartite working group, representing 88 member countries with maritime interests, was set up in 2001, and given the task of drafting a consolidated maritime labour instrument. Annual meetings between 2001 and 2004 were held to progress development of the draft. This group and its various subgroups produced the draft for the Maritime Labour Convention. In 2004, the draft convention was presented to the Preparatory Technical Maritime Conference, which was attended by over 500 delegates. This conference adopted the structure and most of the content of the draft proposal. A follow-up discussion of the conference took place at a tripartite intersessional meeting in 2005 to resolve the outstanding issues carried over from the conference. In 2006, at the 94th International Labour Conference, which included the 10th Maritime Session, the Maritime Labour Convention was adopted. There were 314 votes in favour, 2 abstentions, and no objections. The convention is also referred to as the Consolidated Maritime Labour Convention, or the Bill of Rights for Seafarers. The ratification criteria that were set were that the convention had to be ratified by at least 30 member states, which had a total share of at least 33% of world tonnage. These criteria were met on the 20th of August 2012. Entry into force for the convention were set for 12 months after the ratification criteria were met. Therefore, the convention entered into force on the 20th of August 2013. As well as consolidating the existing labour conventions and recommendations, the main aims of the convention are to set minimum standards for seafarers to work on ships and to ensure good working and living conditions for seafarers by addressing such issues as conditions of employment and standards of accommodation, recreational facilities, food and catering, health protection, medical care, welfare and social security protection, and also to encourage compliance by ship operators and owners through flexibility in adaptation by individual governments to implement the requirements under their own individual laws and practices, and finally to ensure there is compliance through the necessary procedures for complaints, supervision and inspection by strengthening enforcement mechanisms at all levels. To achieve the fourth aim will require that on-board and on-shore complaint procedures are available to seafarers, and that ship operators and owners and ship masters actively supervise the conditions on their ships. It will also mean that the flag states have jurisdiction and control over ships on their registry, and that port state control will be able to inspect foreign ships. In achieving these aims, the Convention should help to improve the quality of life of seafarers, both on board ship and ashore, and in doing so, increase the quality of shipping in general. The Convention applies to all ships engaged in commercial activities and the seafarers working on those ships, with the following exceptions. The Maritime Labour Convention 2006 does not apply to ships which navigate exclusively in inland waterways, or within or closely adjacent to sheltered waters or areas where port regulations apply, or ships engaged in fishing, or any traditionally built ships, such as dhows and junks, or to warships and naval auxiliaries. There is also provision for individual governments to exempt some small ships below 200 gross registered tonnage from parts of the Convention. It is worth noting at this stage that in the Articles of the Convention, MLC 2006 defines a seafarer as any person who works or is engaged or works in any capacity on board a ship to which the Convention applies. This definition is currently causing much discussion with regard to persons working on cruise ships and workers temporarily on board doing repair work or similar. As well as being fully supported by all members of the ILO, the Convention and its ratification is also backed by other important international bodies with maritime interests. These include, but are not restricted to, the International Maritime Organization, the International Chamber of Shipping, the International Shipping Federation, the International Transport Workers Federation. In this chapter, we have considered the background to the MLC 2006 and the ratification criteria, and also the entry into force of the Convention and the extent of the application of the Convention. In the following sections, we will consider the structure and a brief overview of content of the Convention. Before moving on to the next chapter, you should complete the following self-test questions to check what you have learned so far. After successfully completing this lesson, you will be able to describe the main structure of the Convention and its amendment process. Before considering the content of the Maritime Labour Convention, it is necessary to first understand its structure and the amendment process. This should help you to understand how to use the Convention document to find information that may directly affect you, and also how any future amendments may be made. As you can see, the Convention consists of 5 components. First, there is a preamble or introduction. Then there are the articles, and the titles, and the regulations, and finally there is the code. There is also an appendices linked to one of the titles, as we will see later. 3 of the 5 components are considered to be the main components of the Convention. They are the Articles, the Regulations and the Code. Click on the buttons to learn more about the components. We recommend that you begin with learning more about the Preamble component of the Convention. So click the Preamble button when you are ready. The Preamble explains the reasoning for the introduction of the new convention as a replacement and extension of the numerous existing labour conventions and recommendations. It also includes clear statements of intent regarding the intended flexibility that should be built into the convention to ensure that it will be rapidly and readily adopted by member states. And that concludes this introduction to the Preamble component of the convention. Click on the Repeat button if you would like to repeat this introduction, or click on the Articles button to learn about the articles. There are 16 articles which give broad statements to the principles and obligations of the Convention. The 16 articles cover the following topics relating to the Convention: the general obligations of parties to the Convention, and the definitions and scope of application of the Convention, the basic rights of all workers, and the employment and social rights specifically for seafarers, the responsibility for the implementation and enforcement of the laws relating to the Convention by ratifying members, and those members' duties to meet the requirements of the regulations and Parts A and B of the Code, the requirement for members to consult with shipowners and seafarers' organisations with regard to application of the Convention, the conditions for entry into force of the Convention, and the conditions for denouncing the Code once it has been ratified by the member, the effect of entry into force on existing labour conventions. Articles 11 and 12 cover the notification and registration of ratifications and denouncements of the Convention. Article 13 instructs the governing body of ILO to set up a special tripartite committee with special competence in the area of maritime labour standards to continuously review the working of the Convention. Articles 14 and 15 cover the requirements for amending the Convention and the Code. Article 16 is a simple statement that both English and French versions of the Convention are equally authoritative. That concludes this introduction to the Articles component of the Convention. Click on the Repeat button if you would like to repeat this introduction, or click on the Titles button to learn about the titles. There are 5 titles which broadly define the areas covered by the Convention. The first one is Minimum Requirements for Seafarers to Work on Ships. The second one is Conditions of Employment. The third one is Accommodation, Recreational Facilities, Food and Catering. The fourth one is Health Protection, Medical Care, Welfare and Social Security Protection. And the final one is Compliance and Enforcement. And that concludes this introduction to the titles component of the Convention. Click on the Repeat button if you would like to repeat this introduction, or click on the Regulations button to learn about the regulations. The regulations are arranged in 5 groups under each of the titles and cover the content indicated by each title. The number of regulations under each title varies, but in total there are 22 of them, plus 8 sub-regulations. We will look at these in more detail in the Content section. That concludes this introduction to the Regulations component of the Convention. Click on the Repeat button if you would like to repeat this introduction, or click on the Code button to learn about the Code. Each individual regulation may be linked to a section of both Part A and Part B of the Code. The Code contains the detailed requirements of the Convention. Part A of the Code is the mandatory part, and is referred to as the Standard. Part B of the Code is non-mandatory, and is referred to as the Guideline. In general, Part B of the Code contains much of the content of the existing labour standards that it was felt were the main obstructions to ratification of those earlier standards by member states. Although Part B of the Code is non-mandatory, it cannot just be ignored. Member states must show that they have considered this part of the Code when ratifying the Convention, and give reasons for any parts that are not fully addressed. Again, we will look at the detail of the code in the Contents section. That concludes this introduction to the code component of the Convention. Click on the Repeat button if you would like to repeat this introduction, or click on the Appendices button to learn about the appendices. The appendices contain the 4 separate appendices which apply to Title V of the Convention. These appendices contain specimens of certificates relating to compliance with the Convention, and also detail the general areas to be inspected by port and flag state inspections. Again, we will look at the detail of the appendices in the Contents section. That concludes this introduction to the appendices component of the Convention. Click on the Repeat button if you would like to repeat this introduction. As mentioned previously, Article 15 and Article 16 gives explicit instructions on how to amend the Convention. There is no need to go into full detail in this module of the procedures to be followed for these amendment methods. For our purposes, a brief and general summary of the procedures is sufficient. Click on the buttons to learn about the amendment procedures. Amendments to the articles and regulations can only be made by explicit amendment by the General Conference of the International Labour Organization. These amendments are subject to the same adoption and ratification criteria as the original convention. The code can be changed either by explicit amendment or by tacit amendment. Tacit amendment is an accelerated process for adopting changes to the code. An amendment to the code may be proposed by either the Director General of the ILO or by one of the ratifying member states with the support of 4 others, or by the group of shipowner representatives, or by the group of seafarer representatives. Entry into force of an amendment requires that it is considered by an appointed tripartite committee, which agrees to adopt it after a consultation period with all members. The amendment requires the support of at least 50% of each of the groups involved, and a 2/3 majority of the appointed committee. It will then come into force 6 months after these modified ratification criteria are met. Every effort has been made to ensure that the Convention is robust, but at the same time has the flexibility to ensure full implementation and compliance of the regulations and Part A of the Code. In order to allow individual governments more flexibility in implementing the Convention, provision is made for them to match the requirements of Part A of the Code with their own national laws and regulations, provided that these laws and regulations generally meet the objectives and principles of the Code, and that they give similar provision as the parts of the Part A of the Code that they relate to. This is referred to as substantial equivalence. In this chapter, we have considered the structure of the Maritime Labour Convention 2006, and the different ways that amendments can be made to both the Convention and the Code. In the next chapter, we will look at the content of the Convention. Before moving on to the next chapter, you should complete the following self-test questions to check what you have learned so far. After successfully completing this lesson, you will be aware of the main regulations contained in the Convention, know that Part A of the Code is mandatory, and be familiar with the main scope of it. Know that Part B of the Code is in the form of guidelines, and be familiar with the main scope of it. The actual convention contains over 100 pages of text. It is therefore only possible to summarize the key points in the content in this introductory module. You will need to refer to the full text of the convention for the actual detail of the code. For our purposes, it will be sufficient to consider the parts of the code under each of the regulations within the 5 titles of the convention. As an example, we will consider Regulation 1.1, the minimum age. The regulations are set out under a heading, followed by a clear statement of purpose, a number of regulatory statements relating to the regulation, and usually a Part A code section which stipulates the mandatory requirements, the standard, and a Part B code section which stipulates the non-mandatory guidelines. Let us start with Title 1, the minimum requirements to work on a ship. There are 4 regulations under this title, and all of them relate to the minimum requirements for seafarers to work on ships. Click on the buttons to get an overview of the regulations under this title. The purpose of Regulation 1.1 is to ensure that no underage persons work on a ship. The Part A code for Regulation 1.1 stipulates the minimum age for seafarers to work on ships as 16 years old and 18 years old for night work. Exceptions to the night work requirement can be made where the work is deemed an essential part of training of the seafarer. Night is defined as a period of 9 hours, starting no later than midnight or finishing no earlier than 5 o'clock in the morning. It is prohibited for seafarers under the age of 18 years old to be given work which is likely to jeopardize their health or safety. Part B of the Code for Regulation 1.1 recommends that special attention be paid to the regulation of working and living conditions for persons under 18 years of age. The purpose of Regulation 1.2 is to ensure that all seafarers are medically fit to perform their duties at sea. Part A of the Code for Regulation 1.2 stipulates that each seafarer must have a valid medical certificate before they can work on a ship. It also lays down the requirements for the status of the medical practitioner issuing the certificate and the period of validity of such a certificate. Part B of the Code for Regulation 1.2 recommends that guidance from the ILO, the IMO, and the World Health Organization regarding medical examination should be followed. The purpose of Regulation 1.3 is to ensure that seafarers are trained or qualified to carry out their duties on board ship. Regulation 1.3 covers the requirements for all seafarers to be trained or competent or otherwise qualified to carry out their duties and to have also completed training for personal safety on board ship. This is to be done in accordance with IMO mandatory instruments. There is no Part A or Part B code associated with Regulation 1.3. The purpose of Regulation 1.4 is to ensure that seafarers have access to an efficient and well-regulated seafarer recruitment and placement system. Part A of the Code for Regulation 1.4 stipulates that seafarer recruitment and placement services operating in a member state should offer fair employment opportunity to all seafarers at no charge. It goes into great detail regarding the member states and the placement and recruitment services' responsibility to ensure that seafarers are adequately qualified and healthy. It also includes the requirement that the employers that the seafarers are recruited for or placed with are suitable and will ensure their rights are protected, and how this should be supervised. Part B of the Code for Regulation 1.4 recommends a whole range of organizational and operational procedures and practices to ensure the placement and recruitment services operate in a fair manner and are accountable. There are 8 regulations under this title, and all of them relate to seafarers' employment conditions. Click on the buttons to get an overview of the regulations under this title. The purpose of Regulation 2.1 is to ensure that seafarers have a fair employment agreement. Part A of the Code for Regulation 2.1 stipulates that seafarers' employment agreements must be clearly written and legally enforceable, and include the information detailed in the Code. Seafarers must be given the opportunity to review the agreements and seek advice if necessary. The agreement should also include any collective bargaining agreements that may apply. Part B of the Code for Regulation 2.1 recommends that the record of employment given to the seafarer has sufficient information on sea service to allow the seafarer to get further work, upgrading or promotion. The purpose of Regulation 2.2 is to ensure that seafarers are paid for their services. Part A of the Code for Regulation 2.2 stipulates that seafarers should be paid regularly at no greater than monthly intervals. It also requires that means are provided to allow seafarers to have all or part of their wages paid to their families at regular intervals and on time at a reasonable cost. Part B of the Code for Regulation 2.2 recommends that there is no discrimination shown as far as rates of pay are concerned. It also recommends the number of hours for a working day and a working week, and the overtime rate in terms of basic pay rate, and also that records of overtime are maintained on board. It also defines a number of terms used in this part of the Code. The purpose of Regulation 2.3 is to ensure that seafarers have regulated hours of work or hours of rest. Part A of the Code for Regulation 2.3 stipulates that seafarers' hours of work or hours of rest should be regulated, taking into account operational requirements and the dangers associated with fatigue. Hours of work should be no more than 14 hours in a 24-hour period and no more than 72 hours in a 7-day period. Hours of rest should be at least 10 hours in a period of 24 hours and 77 hours in a 7-day period. It also requires that seafarers are given 1 day of rest each week. Exceptions are detailed with regard to emergency situations. It also stipulates that the schedule must be clearly displayed on board the vessel and that individual records of work or rest are maintained. Part B of the Code for Regulation 2.3 recommends that seafarers under the age of 18 years do not work longer than 8 hours per day or 40 hours per week. The purpose of Regulation 2.4 is to ensure that seafarers have adequate leave. Part A of the Code for Regulation 2.4 stipulates that seafarers are given a minimum of 2.5 days paid leave for each month served on an annual basis. As a general principle, annual leave should not be cashed in. Part B of the Code for Regulation 2.4 includes recommendations covering calculation of leave entitlement at normal pay rates. It identifies the various situations that should not be counted as part of the annual leave, such as shore leave in port. Part B also contains recommendations covering the time and place at which annual leave can be taken, and provides for the way in which leave can be divided into shorter periods or accumulated into longer periods. Consideration is also given to the treatment of young seafarers in respect of leave entitlement. The purpose of Regulation 2.5 is to ensure that seafarers are able to return home. Part A of the Code for Regulation 2.5 stipulates that seafarers have the right to be repatriated at no cost to themselves under normal circumstances, and that financial security must be provided by the ship owner or operator to ensure this happens. It also details the responsibilities of the competent authority of the flag state with regard to seafarers who have not been repatriated, having met all of their contractual employment requirements. Part B of the Code for Regulation 2.5 includes recommendations that will ensure that seafarers are repatriated without cost to themselves in a range of situations. The purpose of Regulation 2.6 is to ensure that seafarers are compensated when a ship is lost or has foundered. Part A of the Code for Regulation 2.6 stipulates that ship owners should pay an indemnity to each seafarer against unemployment resulting from ship loss or foundering. Part B of the Code for Regulation 2.6 gives recommendations relating to calculation of the indemnity. The purpose of Regulation 2.7 is to ensure that seafarers work on board ships with sufficient personnel for the safe, efficient and secure operation of the ship. Part A of the Code for Regulation 2.7 stipulates that flag state laws should ensure that ships have an adequate number of qualified crew to meet the purpose of this regulation. Part B of the Code for Regulation 2.7 recommends that members ensure that procedures to investigate and settle disputes relating to manning levels are in place. The purpose of Regulation 2.8 is to promote career and skill development and employment opportunities for seafarers. Part A of the Code for Regulation 2.8 stipulates that Member States should have national policies to encourage career and skill development and employment opportunities for seafarers. The aim of these policies should be to help seafarers to strengthen their competencies, qualifications and employment opportunities. After consultation with shipowners and seafarers' organisations, members should establish clear objectives for vocational guidance, education and training of seafarers. Part B of the Code for Regulation 2.8 recommends that registers for the employment of seafarers should include all occupational categories, and that priority is given to employing seafarers on such registers. There are only 2 regulations under this title relating to seafarers' accommodation, recreational facilities, food and catering. This is one of the most detailed sections in the Convention, so only a brief overview will be given in this module. The parts of these regulations relating to ship construction and equipment apply to ships constructed or delivered on or after the date at which the Convention comes into force. Existing ships will continue to be subject to the standards which were current at the time of their build. Click on the buttons to get an overview of the regulations under this title. The purpose of Regulation 3.1 is to ensure that seafarers have decent accommodation and recreational facilities on board. Part A of the Code for Regulation 3.1 stipulates that seafarers' accommodation should be safe and decent and regularly inspected to maintain the standard. It also goes into great detail as to the size and position of living and sleeping quarters and other accommodation. It also covers the standards of facilities that should be included, for example, suitable accommodation lighting, heating and ventilation. It also states that recreational facilities should be provided and maintained, which should improve seafarers' health and well-being. Part B of the Code for Regulation 3.1 goes into great detail as to the additional recommendations relating to seafarer accommodation and facilities. The purpose of Regulation 3.2 is to ensure that seafarers have access to good quality food and drinking water provided under regulated hygienic conditions. Part A of the Code for Regulation 3.2 stipulates that seafarers should be provided with an adequate quantity of good quality food and drinking water. The food should be varied and of suitable nutritional value, taking into consideration religious and cultural requirements of the crew. The food should be prepared and served in a hygienic manner by a qualified or trained cook who should be at least 18 years of age. The galley, storerooms and dining rooms must be regularly and thoroughly inspected with an emphasis on cleanliness and hygiene. Part B of the Code for Regulation 3.2 contains recommendations relating to food preparation and nutritional education and the training and qualifications for ship's cooks. There are 5 regulations under this title relating to health, protection, medical care, welfare and social security protection for seafarers. Again, this is a very detailed section of the Convention, so only a brief overview will be given in this module. Click on the buttons to get an overview of the regulations under this title. The purpose of Regulation 4.1 is to protect the health of seafarers and ensure their prompt access to medical care on board ship and ashore. Part A of the Code for Regulation 4.1 stipulates that seafarers should have access to charge-free medical care both on board ship and ashore. Each member must ensure that all ships that fly its flag have suitable facilities and medical supplies on board, and that all seafarers visiting ports under their jurisdiction have access to the shore medical facilities, including dental care facilities. Part B of the Code for Regulation 4.1 goes into detail as to the recommendations relating to medical training for persons on board ship, inspection, and maintenance of the on-board medical supplies and facilities. It also gives recommendations relating to the cooperation between member states and their ships in relation to health matters. The purpose of Regulation 4.2 is to ensure that seafarers are protected from the financial consequences of sickness, injury, or death occurring in connection with their employment. Part A of the Code for Regulation 4.2 stipulates the ship owner's liability in the event of sickness, injury, or death of a seafarer in their employment. This liability covers the need to provide material assistance and support, to bear any costs that may arise from such an incident, and ensure some scheme of compensation is available for the seafarer. It further details the extent of the liability in terms of a minimum period for maintaining the financial support. This is given as no less than 16 weeks. Part B of the Code for Regulation 4.2 contains recommendations giving further details of the limitations of some of these liabilities. The purpose of Regulation 4.3 is to protect the health of seafarers and ensure their prompt access to medical care on board ship and ashore. Part A of the Code for Regulation 4.3 stipulates that seafarers should be provided with occupational health protection and a safe and hygienic environment while on board the ship. The policies and programs relating to occupational health and safety should be properly administered and monitored. This should include prevention and reporting of accidents and the correction of unsafe conditions. The authority and duties of masters and seafarers' safety representatives should be clearly specified in relation to on-board health and safety. Part B of the Code for Regulation 4.3 recommends the ILO Code Accident Prevention on Board Ship, at Sea and in Port as a suitable reference document. It also gives very detailed guidance as to what the health and safety laws of the member state should cover. The purpose of Regulation 4.4 is to ensure that seafarers working on board a ship have access to shore-based facilities and services to secure their health and well-being. Part A of the Code for Regulation 4.4 stipulates that members should promote the development of facilities, and that where welfare facilities are provided, they are accessible. These facilities should be available to all seafarers without discrimination. Part B of the Code for Regulation 4.4 contains recommendations to member states to provide and finance welfare facilities in suitable ports, to set up welfare boards, disseminate relevant information to seafarers, and provide the necessary assistance and guidance to foreign seafarers in their ports. The purpose of Regulation 5.5 is to ensure that measures are taken with a view to providing seafarers with access to social security protection. Part A of the Code for Regulation 4.5 requires that member states should work towards comprehensive social security protection for seafarers covering the 9 indicated areas and no less favourable than that provided for shore workers. It also requires that, at the time of ratification, at least 3 of these areas are included in the protection provided. Part B of the Code for Regulation 4.5 contains recommendations relating to food preparation and nutritional education and the training and qualifications for ship's cooks. There are 3 regulations and 8 sub-regulations under this title relating to compliance with and enforcement of the MLC 2006. Click on the buttons to get an overview of the regulations under this title. The purpose of Regulation 5.1 is to ensure that each member implements its responsibilities under this convention with respect to ships that fly its flag. Part A of the Code for Sub-Regulation 5.1.1, which deals with general principles, stipulates that each member must establish clear objectives and standards to ensure effective administration, inspection and certification. It also gives the requirement to have procedures to assess that these objectives and standards are achieved. It states that a member may appoint a competent authority to carry out these requirements. There is also a requirement that members ensure that ships flying its flag have a copy of the Convention available to all personnel on board. Part B of the Code for Sub-Regulation 5.1.1 recommends that members or the competent authority cooperate with public bodies and organizations in meeting the requirements of this regulation and the Convention. Part A of the Code for Sub-Regulation 5.1.2, which deals with authorization of recognized organizations, allows for members or the competent authority to recognize other organizations to carry out the inspection and certification functions. It also details how these recognized organizations should act and be monitored. Part B of the Code for Sub-Regulation 5.1.2 recommends the desirable features and abilities of a recognized organization. Part A of the Code for Sub-Regulation 5.1.3, which deals with the certification requirements, stipulates the certification required, the ships that certification applies to, and the inspection requirements and validity of such certificates. The certification requirements include a declaration of maritime labour compliance, a maritime labour certificate, and an interim maritime labour certificate. We will look at these in more detail in the next chapter. Part B of the Code for Sub-Regulation 5.1.3 recommends various ways in which the certification and compliance can be managed. Part A of the Code for Sub-Regulation 5.1.4, which deals with inspection and enforcement, stipulates the requirement for a member to establish suitable means to ensure ongoing compliance with the Convention through inspection of ships. It deals mainly with the required training and competence of the appointed inspectors, their terms of reference, status, powers, and independence. It also includes the need for investigation of complaints, the maximum period between inspections, and the reporting requirements for these activities. Part B of the Code for Sub-Regulation 5.1.4 details further recommendations to make the inspections fair and thorough. Part A of the Code for Sub-Regulation 5.1.5 stipulates that each member must establish procedures for dealing with onboard complaints which prohibit and penalize any kind of victimization. The ongoing complaint procedures should allow fair and effective handling of complaints in reasonable time. The procedures should also allow for the resolution of complaints at the lowest level possible, the right to complain directly to the master, or if necessary external authorities, and also that seafarers may be accompanied or represented during complaint procedures. Seafarers must be fully informed of the complaints procedure and also have access to confidential and impartial advice on board. Part B of the Code for Sub-Regulation 5.1.5 recommends outside bodies, such as ship owners and seafarers' organisations, are consulted when procedures are drawn up. Sub-Regulation 5.1.6 deals with marine casualties and the need for cooperation between members during any inquiry into a major incident. The report on such inquiries should be made public. There are no provisions in either part of the Code relating to this sub-regulation. The purpose of Regulation 5.2 is to enable each member to implement its responsibilities under this Convention regarding international cooperation in the implementation and enforcement of the Convention standards on foreign ships. Part A of the Code for Sub-Regulation 5.2.1, which deals with inspections in port, stipulates that inspections carried out by port state control officers should be limited to the requirements of the Articles, Regulations and Part A Code of the Convention. It also details the circumstances under which inspections should be carried out and how deficiencies should be reported and acted upon. Part B of the Code for Sub-Regulation 5.2.1 recommends that members develop inspection policies in cooperation with other members to ensure consistency by adopting internationally agreed guidelines. Part A of the Code for Sub-Regulation 5.2.2, which deals with onshore seafarer complaints handling procedures, stipulates that each member must establish a system whereby seafarers can report alleged non-compliances to an authorised port officer. A key requirement is to safeguard confidentiality in the event of a complaint. Part B of the Code for Sub-Regulation 5.2.2 gives recommendations for port officers handling complaints on establishing whether the ship's onboard procedure has dealt with it. The purpose of Regulation 5.3 is to ensure that each member implements its responsibilities under this Convention as pertaining to seafarer recruitment and placement and the social protection of seafarers. Part A of the Code for Regulation 5.3, which deals with labour supplying responsibilities, stipulates that members must ensure that licensed seafarer recruitment and placement services operating under its jurisdiction are properly monitored. The services should be inspected for compliance with the requirements of the Convention and legally accountable for any breaches. Part B of the Code for Sub-Regulation 5.3 recommends that private seafarer recruitment and placement services within a member's territory should be obliged to ensure fair treatment of seafarers. In this chapter, we have considered the content of the Maritime Labour Convention 2006 by looking at the individual regulations and associated code. In particular, we have looked at the purpose of each of the regulations and identified the main requirements of the Part A Code. We have also considered the recommendations given in the Part B Code. In the next chapter, we will look at the areas of responsibility, the certification and inspection criteria as required by the Convention. Before moving on to the next chapter, you should complete the following self-test questions to check what you have learned so far. Title 5 of the Convention deals with the certification and has model certificates included in the appendices. The certification that needs to be considered is the Declaration of Maritime Labour Compliance, the Maritime Labour Certificate, and the Interim Maritime Labour Certificate. The Declaration of Maritime Labour Compliance is in 2 parts. In each part, there are 14 topic areas relating to various regulations that need to be addressed. These areas and the associated regulations are shown here. Click on the buttons for a closer look at the document. Part 1 of the DMLC must be completed by the competent authority or approved recognised organisation. Entries must be made by the competent authority to show how the 14 identified areas relating to specific regulations have been addressed by the member state within its national laws. There are also sections in Part 1 of the DMLC which also need to be completed for any substantial equivalencies that the member state has agreed with the ILO and for any exemptions granted by the competent authority. Part 2 of the DMLC must be completed by the shipowner to identify how the same 14 areas are being addressed to ensure ongoing compliance. The Maritime Labour Certificate is issued by the competent authority to a ship when all of the requirements of the Convention have been met. This certificate is valid for 5 years and only when a DMLC is attached to it. An intermediate inspection must be carried out to maintain validity of the certificate. Click on the buttons for a closer look at the document. Here is the first page of the ILO model for the Maritime Labour Certificate. As you can see, this will contain the details of the member state, the competent authority, and the particular ship when completed. Here is the second page of the ILO model for the Maritime Labour Certificate. As you can see, this is a confirmatory statement that the vessel has complied with the requirements of the Convention following inspection by the competent authority. It also contains details of the validity period for the certificate, and details of when the inspection was completed, and a section to confirm that the mandatory intermediate inspection has been carried out. This is the third page of the ILO model for the Maritime Labour Certificate. This part is a record of any additional inspections that have been carried out. The Convention requires that all ships over 500 gross registered tonnage flying the flag of a ratifying member state must carry a Maritime Labour Certificate. As the name suggests, this is a temporary certificate which is issued to a ship only under certain circumstances and is valid for no more than 6 months. These circumstances are when a new ship is delivered, or when a ship changes flag, or when another shipowner takes over the operation of the ship. The additional requirements for issue of an interim certificate are that the ship has been inspected as far as reasonably practicable in accordance with the Convention requirements, and that the shipowner has demonstrated to the competent authorities that adequate procedures are in place for compliance. It is also required that the master is familiar with all requirements of the Convention and that the relevant information has been submitted to the competent authority to produce a DMLC. Inspection of ships is required under the Convention to ensure initial compliance and ongoing compliance. The areas to be covered during flag state inspections are listed in Appendix A51 of the Convention. Exactly the same list appears in Appendix A53 of the Convention for port state control inspection. Click on the buttons to learn more about these 2 types of inspections. In this final chapter, we have considered the various areas of responsibility under the MLC 2006. We have also considered the various certification requirements and looked at some models and examples that have been produced by the ILO. Finally, we have considered the different inspection regimes, both flag state and port state control, which ships will be subject to once the Convention enters into force. Before moving on to the final assessment, you should complete the following self-test questions to check what you have learned so far.